Hey guys, Brent Sibley, Sibley Dolman Accident Injury Attorneys, and today I'm going to talk about the fact that you have to use your own car insurance even when someone else causes the crash. Is that true? Yes, it actually is. In Florida. You may have heard that Florida is a no-fault state, but what does that really mean? It doesn't mean that you can just go around causing crashes and it doesn't matter because it's a no-fault state. No fault doesn't mean that there's no fault for the accidents that you caused. That has nothing to do with it. What it means is that the first $10,000 of treatment after a car crash are independent. The person who pays for those, the insurance company that pays for the first $10,000 of treatment, that is independent on fault. That doesn't matter about fault. So you could be driving along, get rear-ended by a drunk driver going 100 miles an hour. He's super at fault and he's drunk. He's 1,000,000% at fault. If you have to go to the hospital, guess whose insurance pays for your first medical treatment? Your car insurance. Yup. It's super messed up in many ways, but that is the law in Florida. That is your PIP, or your no-fault insurance. Now, you may have heard some advertisements. I don't like to name names, but you may have heard some billboards and radio jingles. $10,000 of benefits for you after a car crash. That is your PIP coverage, but it doesn't put money in your pocket. For the most part, what it does is it will pay for your medical bills, $10,000, up to $10,000, and it will pay some of your lost wages. So you're never going to be making out better as a result of doing a PIP case. That's your car insurance. It's never gonna make you better off. Now, let's differentiate that from your personal injury case, which is if you hire a lawyer to do a personal injury case, we are not pursuing a case against your PIP insurance. The two main kinds of insurance that we are pursuing is the BI insurance. That's for the person who hit you. And depending on how much BI insurance they have, because there's a chance in Florida they might not have any. Florida doesn't even require people to purchase injury liability insurance, bodily injury liability insurance, for the injuries that they cause other people. It doesn't require it. Again, it's another thing that is a little bit ridiculous. We're one of only a few states that still operates like this. And if the person who crashes into you doesn't have the BI coverage, then we still may be able to pursue a case for you, but that depends on if you had purchased coverage on your auto policy when you did your insurance policy. So you have Geico, the person hits you has Progressive, they don't have bodily injury insurance on their policy at all, they have zero. You have 50,000 of on your policy, now you have up to $50,000 to do a case. Or let's say the person who hit you had 25,000 and you had 50, now your lawyer, me sometimes, would be able to do a case of 25 plus 50, so you would have a case of up to 75,000 in insurance. But going back to the main topic, which is you have to use your car insurance to cover the beginning $10,000 of medical treatment after your case. This is by law. It's absolutely mandatory. And what's worse also is that the insurance company on the other side, the person who crashed into you, they are allowed to take a settlement offset of $10,000 against you. So let's say you're driving and they crash into you and you go to the hospital and you have a herniated disc. The law says that when if their insurance company offers you $5,000 to settle your case, if you were in court and you were going to trial, that would actually be considered a $15,000 offer, because whatever they offer you, they get to subtract $10,000 off of it. So if you were to take your case to trial and the jury gave you $15,000 as a result of your trial, the judge, the week after the trial, when we go back for the post-trial motions, the judge would actually subtract that $10,000 from the verdict that the jury gave you for 15. So you would actually be reduced down to 5,000. And guess what? If you don't use your PIP insurance because you're worried that your insurance rates are going to go up, or you're just so scared of doing an insurance claim on your policy and you only want to go through the other person's insurance, which is, we get this, we have to explain why that's not a good idea. Even if you don't use your PIP insurance, the judge still can subtract. He still has to subtract the $10,000 that you could have gotten for your PIP case, because that's the way the law is written, the Florida no-fault statutory law. So, a lot of information in this video. I hope it helps you understand why you have to use your Florida PIP no-fault insurance after a car crash case, regardless of who is at fault in the case. Brent Sibley, Sibley Dolman, personal injury lawyers, accident injury attorneys, here to help you. Give me a call. Always 100% free consultation. But anyway, either way, I just hope this video helps you guys understand why, your attorney might be telling you have to do this. It sounds a little bit counterintuitive, and it is, and we're one of only a few states that still forces you to do it this way. Have a good one, guys. See you in the next one.